computer. All right, it's on record. Is everybody able to see the shared screen?
Yes.
Yes.
All right.
Yes.
Yes.
So getting started, Intellectual Property 101, a guide to filing patents and other considerations. So the main purpose of this is, of course, how do I turn this guy into a millionaire, right? I mean, that's what we kind of think of when we think inventor and why would you invent something and why would you file a patent? It really is to, sort of claim your intellectual stake in the ground and be able to reap the financial rewards of that. There's a lot of things that take place in between these steps. And hopefully we can learn some of the things that you need to consider and what are some of the benefits. Okay, so first of all, what exactly is a patent, right? It's this piece of paper that you get from a federal agency that says you have exclusive rights for something. But in exchange for letting you have exclusive rights for a piece of intellectual property, or what that really is saying is that you actually also have to disclose this to the public. So you need to let the public know what do you know and what's so special about it. Now that they know about it, it's supposed to help the inventor and it's supposed to help the society be able to build on top of that, to make things better and not to sort of hide things away if you think it's helpful. It's given a limited term. And so in our case in the United States, it's 20 years from the day that you file your patent. So that includes a couple of years of prosecuting, like making sure that you actually should have the patent. And then, all the time after that. Does anybody have any questions on excluding things or any of these bullet points?
Can you extend the your patent time, I guess, or the length of your patent?
There are special occasions. That's a good question. There's special occasions where you can actually. If it was a really troublesome prosecution. So like if for some reason, it takes like 4 or 5 years for you to solve this in court and with the office to get this through, they'll give you a little bit of an extension, but not much. It's probably less than a year, most likely.
Okay, thank you.
Yep.
Oh, Richard,
yeah.
Do some inventors exclude some part of their technology from the patent and intentionally not disclose the entire invention?
Another great question. So the answer is yes and legally no. Yes, there are parts of your invention that you don't want anybody to really know. And so what you do is you exclude them and maybe you call it a trade secret. But the reason why I say legally no is, let's say when you're filing your patent, there's this end result that you're trying to achieve. Anything that you need to do to get to that end result that's critical to that, you need to disclose it. If you don't disclose it, that's a failure to disclose, which means, hey, thanks for telling me that this is a really efficient engine, but you never really told me how it became so efficient. And because you didn't tell me how, you didn't enable it, meaning you didn't let me know how to do it. So what's the point of filing this patent? You're just telling me a result. So it's like you gave me answers to a test, but I don't know, how you thought your way through it.
Great. Are you going to discuss what the different types of patents are, the process, design, application?
Yep, utility, design, plants. We'll definitely be going through those different things. So types of patent. Utility is the most typical type of patent, which is a function, a process, or a method. A design is how it looks, right? Like a particular stylistic improvement, a stylistic improvement. Let's see. Michia, I'm going to ask you to be the co-host to allow people in. Maybe I'm missing people as I'm kind of giving a lecture. Will that be okay? Okay. And so, yeah, design is like, oh, look at how that Nike shoe looks, right? There's a design that Nike shoe has that's really special. And so that would be a design patent. That's a 14-year term the day it gets granted. And the last one is a plant patent. So let's say there's a natural occurring tomato that's out there. You can't patent something that has already happened in nature. But what you can do is you can patent certain aspects or certain modifications that you've made to the plant. So the tomato you can't patent, but maybe a resistive type of, outer skin of a tomato to resist pests, you can patent that aspect of it. Okay, it's a little bit complicated to understand, but for the most part, what everyone thinks of a patent is usually called a utility patent. Like, hey, I invented a new board game, board game play or something like that. Does anybody have questions on this slide? Nope. Okay. So why should you get a patent? I think a lot of us think that we should get a patent because we have really great ideas, and these ideas are going to be, millionaire ideas. Very often, if I'm taking an airplane ride cross country, and if I tell people that, oh yeah, I work with patents, suddenly they have the greatest idea, and they always, they're determined to let me know what it is, and should they patent and so forth. And you have to make those types of decisions yourself. But here are the reasons, the typical reasons why, and I would call them responsible reasons why you would get a patent. Gaining market entry, being able to be first into a market, excluding others. Your competitors may try to get market share, and if you developed a process or something that can really outmaneuver them, you should get this so that you can, push them out of a market or get into a different market. A marketing tool. So if you invented something new and you need capital to either license it or to be able to get manufacturers or even suppliers to utilize this new invention, um, they would look for your intellectual property portfolio to make sure that you're actually not only able to do it, but okay, you have legal protection to actually execute this without fear of litigation from another player in the market. And a very typical one is selling it or licensing the intellectual property to another player in the market to actually, they may have scale, they may have capacity to actually build it and to get it to the people in a reasonable time. All right. Does anyone have any questions on this slide? Nope. Okay. So let's look at our cell phones as a nice analogy or a nice analog for us to think about intellectual property. What people know as trademarks would be, hey, there's a name or a marketing signature identifier for a product that's being sold. That's a trademark. So in this case, like the Google Pixel 5, made by a company called Google. The product designation is Pixel 5 in this case, and the software name on this is Android, right? Now, the parts that are patents are maybe the CPU architecture, the different chemical compounds that are needed in order to create semiconductor to operate this cell phone, antenna design. Stuff that I used to do was power control systems, battery control systems, communication modules, antenna design. So those are the things that I worked on back in the day. Um, And now there's the copyright section, which is, oh, the software code that may be here, the instruction manual that comes with the device, the different media that may be associated with the device, like the ringtone. So hopefully this is a really a common analog that can be used to understand this. And this one might be a little bit more complicated. Does anybody have questions here before I move forward? Nope. Okay. All right. So this is a very preliminary view of what prosecution means. And what prosecution really, all that means is, hey, I have an idea and I want to determine if my idea is legally valid as a patent in the United States, in this case. And so what happens is, let's say we'll start here at application undergoes pre-exam. So what that means is they'll take a look at your application, make sure it's not deficient. You know, hey, I don't see any drawings. Can't figure out what this is. Hey, I don't really understand this is the United States, but you filed a patent in Japanese. That happens actually quite often, where like it doesn't meet the standard for a proper filing. Next, it goes through a classification, which means I used to look at stuff like mobile devices, satellite systems, radar systems, and architecture. What I did not see was like solar panels, you know, AI, you know, I don't know, VR goggles, right? That wasn't my area. So I didn't have an expertise in that. So what happens in this step is they actually classify the right patents, the applications to the right examiner. I have a friend, the only thing that he ever examines is wall mirrors, right? So like the mirror that you hang in your wall or your closet. There are only 2 examiners who do that, who do those cases in the entire patent office. Back in my day when we were doing cell phones, there were about 2,800 of us doing cell phones. So there's not a lot of innovation in the wall mirror space, so they only needed two examiners. And I had other friends, they did board games, right? So anytime a new gambling machine came out or a new board game would come out, they would examine the case to see if that game hasn't been done before. And then here on the middle row, this is where someone like myself would get involved. You send in your patent application and the examiner will take a look at it and say, it looks okay. There are these other things here that look pretty similar to what you're doing. And so I'm going to reject it first. And you have to overcome whatever I presented to you. As an attorney, my job is to give you pieces of evidence, and then you have to say my evidence is wrong, or you have to say, hey, your evidence is right. But look, there's this other part of our invention that's a little bit different from here. So we think this is actually... Hello? Okay. And this is a little bit different. And so it goes through this process. And at the very bottom, you see applicant appeal. And so this is where I spent most of my career. So I served on the Board of Appeals Court. I was an appeals prosecutor. So if the applicant, the inventor, is really just like, hey, look, man, you're not examining this case correctly. I'm going to bring this to a court. I'm going to take you to court, and at court, they will decide whether you're right or I'm right. And so the court, an appeals court, is always like a panel, in this case, a 3-judge panel. And so I represent the US government, the inventor, they have their attorney, they come in. And what we'll do is we'll do oral arguments in front of the panel of judges, and they have to explain their position. I explain my position. And at that point, the judge says, yeah, the examiner's right, throw it back down there. Or it's like, hey, examiner's wrong, this should be allowed. It still goes back to the examiner, but the examiner now has to sign off. The judges can't sign off on a patent, only an examiner can sign off on a patent. And that becomes a notice of allowance, which is, hey, cool, you got your patent and it gets granted. Or it gets rejected, and the inventor just gives up and doesn't pursue anymore. So, I mean, this is getting kind of in the weeds, but this is what happens when you're trying to file for a patent and the legal process. Does anyone have any questions on this slide? Nope. Okay. So these are things that, as an inventor, things that you should consider before, saying, hey, I should file a patent. There's a cost benefit analysis that is really very necessary to do before you want to spend up to 25,000 would still be a pretty reasonable amount of money just to get a patent. You should really have professionals to actually search the patent database to tell, hey, your invention, as at least the way you've said it is, there's something in here that's really close to what you're doing. You may not want to keep going forward and spending money to prosecute the case. Strongly also suggest you hire a professional to do it. I personally don't like having to hire attorneys to do this work, not because they're attorneys, just that the over legalization of this process really it's ridiculous. Like, it's no longer an engineering this is no longer an engineering event. This is now a legal event, which unfortunately I think steps away too much from the spirit of why there's a patent system. And yeah, the cost really, really, really high. If you can afford it, your chances of getting a patent, if you have an attorney, skyrocket. If you try to do it yourself, the results are really quite poor. And it's sort of a task in futility, if you ask me. It rarely works out too well, even if they do get a patent. Right. So, a perfect comic strip to sort of describe what inventors are these days, right? Hey, I'll let you read the comic strip, but in my perspective, it really is becoming much more difficult in this society to become a successful inventor. Um, Not because of their engineering or scientific lack of knowledge. It really is a legal process that really sort of outcasts independent inventors quite often. I mean, at the patent office, we've even set up an office that offers free advice to independent inventors to how to get a case to go forward. It's very underutilized, of course. I mean, it's a government program, so it's not exactly easy to find or easy to use. And back in the day, if you invent something, you also had the ability to raise a moderate amount of capital to get the invention into production, and you knew how to sell it and everything. Today's business models and complex distribution systems sort of work away from an inventor's perspective. An inventor is mostly concerned about just, hey, I want to get something new and useful out there. It's hard for them to have that talent and also know how to get things to market effectively. So these are my, sort of complaints about the system. But they are what they are. Another important thing to consider is, hey, where should I patent? There is no one patent system that has the protection from all over the world. What you need to do is to be able to actually patent each country, or in some cases like the European Union, to designate specific territories that you want your patent to be enforced. If I'm trying to create a patent on, processors, it makes a lot of sense to have them in, Europe in general, America, Canada, manufacturing areas like China, Taiwan, Singapore, Japan, South Korea. It doesn't make a lot of sense to get a patent for this in maybe I mean, no offense, like, I don't know, like Ethiopia, Saudi Arabia, maybe Slovenia. These countries are not exactly known as, you know, chip maker or powerhouses, and so it becomes really difficult to pay for protection rights all over the world. And so you want to strategically pick which regions that you want to have controls and have legal rights to have your patent valid. So these are the typical costs that are associated with getting a patent. Yep, you know, yep, it's about $5,000. That's a pretty hard to get $5,000 to get a patent. That's really, really low. What typically happens is, let's say you do get your patent, you're going to be paying a maintenance fee at 3.5 years from the day that you filed, 7.5 years, and 11.5 years. And so you need to pay these fees in order to keep your patent valid. If you don't pay the fees, it goes invalid, and you no longer have the protection rights of the US. A big portion of the cost usually comes up front with the attorney fees to create your application and to get it through the patent process in the first place. So that's usually the big one. And yeah, that is it for me. So now I will open it up for questions for anybody about this process. It doesn't have to be about the slides. It could be just in general, an invention, and like if you want to talk about you know, some old patent stories, I'm more than happy to do that as well.
Can you talk about patent trolls?
Patent trolls, excellent. Okay. What are the qualifiers for something, an entity known as a patent troll? The general accepted definition is an entity that does not actually have engineering or scientific capacity, but merely pays money to either prosecute their own cases or to purchase licenses from like companies, and then they take those patents and then they start executing a very oh, okay. We need to execute a very litigious type of strategy where most of your business operations are actually designed to pick off and to bother people within that industry to pay you a licensing fee or some type of fee for violating a patent that they may have. And so at the patent office, our practical solution is not nothing written in our legal briefs of how we should prosecute a case. I personally, I have a list of companies and lawyers who work as patent trolls, and they're on my wall. And if I see a case that comes from here, it actually triggers me to do an extra search to see if this is indeed a patent troll type of filing. And so the USPTO practically tries their best to stop patents from going into these types of entities because while it's totally legal what they're doing, their business practice actually really hurts the way we do business, as well as, of course, you know, the industry. So there's this provision that's called enablement. Hey, you're patenting this. Can you actually do it? Do you know how to do this? You know, you're just kind of saying something now. Prove to me, give me an affidavit that shows me that you can actually do this. Which is, you know, engineering wise, that means they need the specs and everything to do it. So more typically what they do is, instead of trying to file new cases with us, they'll pick up other people's patents. And then they say, hey, well, I can do it because I have this other patent. So.
Oh, wow. Man, so they're tough to fight, huh?
It's very difficult. It's a perfectly legal business too. Like it's like, I have no problems with patent trolls as a business because it exists in a capital system. My main issue is them inundating the office with applications that they don't know how to do. And that's legally not kosher. You can't do that. Like, let's say if you file a patent, we assume that you know how to do whatever you're saying that you're doing, right? Because you wrote it down.
Yeah.
But we take you at face value and say, okay, this guy said he can do this. Well, okay, we'll take it at face value. If something comes up that lets us know, hey, this person actually doesn't know how to do whatever they're saying, it brings up a red flag. And that red flag is something that we use for entities that don't have much of an engineering capacity. We'll be like, hey, we're not really an engineering company. How did you invent this again? And so we'll ask them to prove it to us by giving us pieces of evidence. And if they can't fulfill their evidence, we'll then send an objection, which means until you provide evidence, we can't keep moving forward. So, um, it's a pretty a useful tool in a patent examiner's toolkit to try to at least slow down patent trolls.
Okay, thank you.
So this is a somewhat related question.
Mhm.
I'm sure you come across a lot of ethical considerations in this type of work. And I'm not talking about, somebody's trying to invent something that, well, maybe I am. Somebody's trying to invent something that is going to be used for very unsavory purposes. I mean, what are some of the ethical things that you face in doing this job? Not just maybe somebody's using nonprofit funds for something that seems not so great, but I mean, it just seems like those questions would come up a fair amount.
Yeah. So I will address an issue that the patent office is very well equipped to deal with. So, which is patents, patents that are designed as weapon systems, as you know, uh, lethal that has a lethal intent to it, right? And I'm not talking about like guns. Guns can be used for protection. We're talking about missile systems, AI systems used to detect personnel for automatic targeting for a rifle, for a mechanized, sniper rifle, and so forth. And these things are engineering innovations that we have no ethical, we have no position on them ethically, right? Like if an examiner chooses not, that they don't want to work on the case because it does violate some of their own personal ethics, we do remove them from the case. But as an office, engineering wise, as long as it meets the if it meets the criteria as an advancement in technology, yeah, we look at the case, and if it gets allowed, it gets allowed. I will also say that our final adjudication, our decision, is purely made on whether it passes the statutory barrier, which is, it it can be a patent, and it passes the non novel and uh, it passes the novelty barrier where it's like, oh, this is really, really new and different, and there's nothing out there that exists like it. And it wouldn't have been obvious to combine a couple of things to make this. That's really where it stops for us as the office. You know, and also, let's say people, we often get these things where people patent devices that are, defy the laws of science, like a perpetual motion machine. We do have mechanisms for us to reject that based on enablement. Doesn't work. You can't do that. And if there's something that's also designed that may also defy certain products of war, like chemical warfare type of substances, uh, we then actually shift those cases to the Justice Department for them to look to see what are the legal basis for actually creating such a thing.
Interesting. Thank you.
All right, Charles.
Richard, can you discuss some of the complications around patenting the work that Carl has been funding in LENR?
Okay. That one, I'll just clarify to everyone that I do have some personal, I've done some personal lobbying for that last year. So just to make sure that I have my bases covered. LENR is a perfect example of what the US government and the patent office is not well equipped to deal with. Yes, our job is to figure out new inventions and new innovations. But what happens is, what happens if something is too new? Like something so new that the general population of even people of expertise, which are, let's say engineers, specifically, maybe chemists, they see this and they're like, I don't believe that. I've never seen that before. How can I allow that? That's a real issue that we have because I think anyone who works in government will tell you that one of the overriding factors into the quality of your job is you have to be very fearful. Meaning, if I put something out there that's so outrageous and I embarrass everyone in my organization for putting something out there, that's the worst thing you can do. You know what the second worst thing you can do? Being courageous and putting something out there that nobody knows what it is, but it's valid. They're not going to reward you at your job. They're going to push you away somewhere and punish you by a million cuts, unfortunately. So in the field of LENR, we had a lecture about this a few weeks ago. It was so new and different. Okay. But it was also mired in this weird cultural, academic hit job, or I wouldn't say hit job, of complexity that some people were really, were heavily for it. Some people were like staking their careers for it. And some people were dismissing it out of, it doesn't make sense. We proved it was wrong. Don't touch it. Unfortunately, that type of weird philosophical idea also permeates throughout the patent office, right? And so when an examiner has to look at evidence that says, why is LENR not valid? Hey, check out this piece by 60 Minutes, or check out these articles in these different academic institutions that tell me why it's not, right? And it would be really hard to convince you otherwise. So what was needed in this case was to actually have people who work in the field whose science is of high quality, and they've shown in their experiments, and they've shown that there are aspects of this that have validity, or there's even maybe taking it further, and actually have the experts come and talk to the examiners at the patent office. And so in this case, this was done last year. I talked to some of the examiners and the supervisor in this area and asked them what their thoughts on the field were. And the answer was evolving. That's the main thing. It's evolving. They'll look at it closer. They've given certain classification areas to it now, which is a very big thing to amend the classification table to include it. And it's just an evolving perspective on new technology. I would say that's. Are there any other specifics you may want me to answer, Charles?
No, I'm just curious. This is something that obviously Carl's invested a lot of time in, and it's just kind of curious to see where it's going.
Yeah. So in this case, from the last time I checked, which was I think 6 months ago or 5 months ago now, the percentage of filings have increased about close to 300%. Allowance rates have gone up 60%. From a very low allowance rate, that's not much, I suppose. But when when talking about a bureaucracy and those types of numbers, quite impressive. Just the honest truth.
Can I ask a question about design patents?
No, yes, please.
So in your presentation, you mentioned Nike shoe as an example.
Mhm.
I assume you mean the style and not, let's say, like the materials for the cushion or something like that.
Yeah.
So I'm just wondering about how you enforce design patents, because I guess in the fashion industry, I feel like someone comes out with a new trend and that trend is quickly copied by other companies.
Mhm.
So do these things actually get enforced?
When it comes to enforcement on all like design or utility, that's determined by the players in the field. You know, they're the ones who can choose to enforce one another. Uh, there are different legal strategies to utilize to defend themselves. But you know, I mean, here a calculation has to be done, right? One of the patents that I had worked on was, it's still a utility patent. Um, it's a button. This is the older Apple iPhones. There used to be the home button, and the home button, there used to be a shape on the home button, right? Does anybody remember what that shape looked like?
Nope.
Nope.
It's a circle.
Kind of. It's kind of a circle, but it was also kind of a square. And they claimed it was a square. And I said, no, you can't claim it's a square. It has to have 90-degree angles to be a square. So let's throw that one out. And this specific argument with Apple lasted about 1 year and 9 months of just the shape and just the designation of the shape. And it's a picture, right? It's like a design, which Rieko had brought up, but why is it a utility patent? I said, well, the utility of the design of this square has there's a lot of, let's call it background, that was really important, that we got this shape. I was like, all right, if you want to get this shape with me, we're going to have to narrow it down so that it cannot be mistaken as something else. So it's a unigonal, or I forgot the exact designation, but it's not a polygon, but it's not, it was a shape that had a certain amount of distance, and the curvature of the sides were of a certain degree, and that shape, you can have that shape. And so I was like, all right, I thought myself, hey, did a pretty good job, narrowed them down pretty hard. Well, they went out and sued Samsung like crazy anyways. And they had to fight it out and settle outside of court for that shape. And so, I mean, it shows you, like, I worked 1 year and 9 months for that case. I was working other cases at the same time, of course, but despite my best efforts, attorneys will come out and find something to get you. And so that's what happened. And there was a lawsuit, it was settled, and all right. The cell phone wars are no longer around anymore, right? No one really cares about mobile engineering lawsuits anymore. It's not that pertinent. So that's an extreme case of a design case going like crazy. But there are also other cases where, yeah, Nike creates a shoe, something from Li Ning kind of looks like it, but it's not exactly like it. Do you want to spend the time to enforce your patent? It's up to you.
I have a quick question.
Okay.
So what if you want to get a patent and you can't afford to spend $25,000 or $5,000 on a patent? Is there a way of financing it through, other means, or do you have to come up with that money up front?
Oh, so when we talk about the cost of the patent,
Mhm.
let's say if you did it yourself, Micah, in total with filing fees with the patent office, it would come out to be, I think, $900 to $1,100 total.
Okay.
If you just went to the office.
Okay.
But most, I mean, by far 90 something percent of the fees that are associated with are from attorneys working with it.
Okay.
The US Patent Office has a pro se assistance desk where they can kind of help you try to file a patent, but they won't write the application for you. They won't go through the legal reasoning with you. They won't go through claim structure with you. They'll just help you, sort of, all right, let's do a quick search and see what's out there, sort of help you know if you should go or you should not go.
Okay. Sure. Thank you.
Yeah, but no, and the government does not provide any financial assistance to file patents.
Okay.
Cool. Anything else?
Richard, are there any examples that you can give in terms of people filing patents when they shouldn't have, or when it made no sense to?
Oh, all the time. I would say probably 95% of the cases are probably not worth it, but it's just a true, like if you're a business, typically there's a council that will have a go, no go for a patent, like is it worth being part of their portfolio? Does it cover certain aspects? And they have a due diligence team that actually goes out and checks to make sure that, filing a patent won't be excruciatingly hard, because there's a pathway that they know that they can get. A lot of people sort of file patent. And this is kind of like what this presentation is about, which is these are the things that you should know about before you file a patent to help you be very reasoned with your dedication to go through with this process. But yeah, I'd say most of the times it's not a good idea. Hey, Charles.
What about just for filing provisional patents?
Okay, filing provisionals is a very easy. It's a very easy type of process that gives you a year to determine whether you want to do it or not. Right? Got a great idea. I want to put it on paper. Send it to the patent office. Get my put my cover page on there and have it there. And you can let that idea stew for a year in your mind to say, I think we got something here. Since I already have the provisional, I already filed it with the patent office. Let me talk to some people. Let me add some improvements, be more specific, and understand my legal strategy, not just my engineering, dissertation. And then I also have to understand that there's a business process that's going to be executing alongside this. Where does it lie, and how do I have all my ducks in a row so that if I say yes from a year from the day I put it to the patent office, I'm ready to do this. So provisionals are great ideas. Let's say you say, forget about it. I'm not gonna go bother doing that. Your provisional disappears, gets shredded up, doesn't count as evidence against you, can't be used as evidence against anybody else either.
Great, thanks.
Yeah, you're welcome.
Richard, there's a website called Justia.
Justia.
Patents.justia. Is that a real site? Because I use it a lot. It's patents.justia.com. And then there's sometimes Stacy and I get pitched by executives. Then they tell us that they have all these patents and we want to do our diligence. We're like, oh, it says they have patents on this website. Have you ever seen that before?
I've never used that, but then again, I use pretty high-powered tools to do my search. You can too, if you visit your local patent office, which is San Jose for you. Yeah, but if you visit the local search room, that tool is a million times better than what I'm seeing here.
But we have to register for that, right?
Register meaning
like to use those patent tools to do research.
I mean, it's free.
Okay.
Yeah, it's totally free. It's just they just need your license, like a picture ID to make sure you are you are who you are.
Okay.
Yeah. But no, I've never used this site before. I can look into it.
That'd be cool. Because you know, some of the executives we work with,
Mhm.
they have in their LinkedIn here, I have like 12 patents on this. Of course, we're not, we actually go through, Stacy and I make sure, just like what you do, but not to that level. To make sure
Oh,
what they say is true is actually true. And
okay.
this is the only site that I've actually looked at a lot in terms of,
Google Patents is good.
okay,
Yeah, just I mean, even if you just Google their
yeah.
name and patents, Google Patents kicks in pretty quickly and lets you know for a scholarly search all their. You can just click on their name and it'll show them everything that they've got.
Sometimes they're
So
not US based though.
Gotcha. Okay.
some of the clients I've worked with, their patents turn out to be about things like, hey, I have this unique process for bringing a product to market, like an idea for a process that is not a product, it's not a design, it's not something concrete.
Oh,
That to me is like total BS, but I think they sort of want to protect it for maybe their book or their whatever. I mean, is that a common thing? Because it just seems like to me, um, patenting a tweak to an idea or a process
Mhm.
has always felt like, maybe I'm wrong, but and maybe that's, linear. There's a bunch of different ways to do lattice confinement, and but so maybe I'm wrong. But the thing is, sometimes I just feel like it's, I don't know. Anyway, weigh in, Richard, because I'm like,
For sure. Just before I address your question, sorry, Eugene. I know I'm late for the next meeting. Can you let Grant and Jim know that I will be there as soon as I wrap up here.
oh my God, patents, Google is awesome.
Yeah, so it's a really interesting predicament that you brought up, right? Like, why does this deserve a patent? Like, what's this small improvement? Why does this deserve a patent? I mean, the reality of the situation, right? Like, we like to judge this as some sort of like, I know what's inventive, you don't know what's inventive. The problem is there's somebody on the other side of the prosecution desk from you, right? Like, just like what you said, Stacy, like, this is not like, let's say this little improvement. Why should this be even a patent? Why should this even be a patent? And the person who paid a lot of money to get this patent says, because I paid for it and I've invented it. Did you invent it? No. It becomes a very emotional discussion, even sometimes, that like, look, the rights of my client, need to be enforced and observed here because you may not like it, but you haven't shown me evidence to the contrary of it, which is very true.
mhm.
This is why I take if people have like, you know, people have ideas, it's fine. It's very difficult for people to show me evidence. That's a different level that you need to sort of work your way up to.
Gotcha.
Yeah, I'm sorry. Like,
No, I mean, it's got to be kind of a fine line and a, different situation, but yeah, the only clients I've had, it's just like, okay, well, that's one, tiny tweak to an existing idea.
Mhm.
I'm sure
Yeah,
it happens all the time.
and yeah, every day, every day, all the time. I mean, that's sort of the progress of humanity as well, right? Like, the one thing the patent office cannot do is halt progress, and so this is why when it comes to like these little tweaks, as long as the adjudication process is done thoroughly, where you've considered all the evidence that's been brought to you, for the most part, it's like, all right, yeah, if there, I don't see anything out there that's really like exactly like that, it's yours. Welcome to the party. You got a patent. You know how valuable that is. That's probably not. You know, time will tell if it's valuable or not, right? Like, we don't make that determination. The business makes that determination. Cool. Any other questions?
Yeah, I think maybe something along this line. So, um, we're seeing a bunch of drugs being discussed for COVID treatment right now, right?
Mhm.
And so they're looking back at some like the so-called blockbuster drugs in the past, and some companies are doing very minor modifications. For example, just adding one extra little carbon to their molecule and trying to patent that. And so um, when it comes to situations like this, does the patent office rely on experts to help guide their decision making, or is it done
Oh,
internally?
no, that's the I'm an electrical engineer, so I work on cases that deal with, communication systems and so forth. Most of the patent examiners who work on, new drugs, new compounds, they're typically, PhDs, people who work in those fields, who make those types of determination. Um, I will tell you that one of the most obnoxious things about my previous career is, let's say there's a circuit board and they added a resistor in parallel to an inductor over here to draw out, some current, or a capacitor here to clean up a signal. You then spend hours just scrolling through different graphs of this system looking for this resistor in parallel. And you're like, oh my gosh, like, can't the computer do this? But no, the computer, at least not when I was practicing. So you would have to literally go through all these circuit designs and your eyes will start tearing up and you're looking for a resistor in parallel to this component. And once you found it, you then have to look at the specification to see if the reason they put the resistor here is similar to the reason why the patent application was done. Most likely not. Whatever circuit design that they may use, the resistor happens to be there. And so what we'll do is we'll use this as evidence, but then they'll just come back to us and say, hey, gotcha, I understand there's a resistor here, but they didn't tell us that there's not a reason why this is here. We're making improvement. Our resistor value is of this level, and that's why there's an improvement. That's how mundane the job can get, where you're just searching for these things. Same thing goes for the chemist when they're looking for new compounds. Like, they're just looking at these chains and they're looking for these patterns that are trying to match it. And if they find something, they'll submit it as evidence. And if it holds, it holds. If it doesn't, then they get their patent. Charles.
So thanks.
I can't believe you could do any kind of chemistry analysis by hand because everything is so nonlinear. I mean, a small change could have a huge impact. There's no way to predict it. I mean, there's sort of crude chemistry rules, but that stuff is it's almost like alchemy.
For sure. And I will tell you that I started at the patent office 2005. They started using computers at the patent office 2001. And so, this is just a real life consequence to, funding the government, right? They didn't use computers to actually do their searches. They actually have, back in the day, they used to have the Dewey Decimal and they have those cards, right? That's how the patent office, those search rooms are still there actually. And what you do is everyone will gather and like, oh, okay, we're looking through all the files and we're looking at it. It's like, oh, okay, that's kind of similar. And people would get paper cuts. People, it was just like the whole deal. Like, those things were still there. And say, I found my evidence. And then they would pick up their paper, tell the secretary, I'm checking this out. I'm going to use this as to write up my case. And they'll just type out their case on a typewriter and write down certain notes and then bring the case back and then they'll file it back in there.
I can comment on the chemistry stuff, Frank, that when I was at Roche, we had a group come in from IBM to discuss this with us. And this was, 20 years ago, maybe 15 years ago, I think. I forget how old I am. And they had a they had a couple of guy at IBM, and all he did all day long was write regular expressions, basically software code, to try to detect chemical variations. And when you would file a chemical patent, they would run it through this massive thing he had to try to look for various variations because we understood that when we filed the patent on the drug, you had to submit all the potential variations, but the variations had to be chemically reasonable, right? You couldn't just commit, it couldn't be random. And so they spent an enormous amount of time doing this. I think there was a famous case where, I don't remember now anymore the details, but there was one company that did this and they missed something like a carbon atom somewhere or a common, whatever it is they missed, and it ended up being worth tens of millions of dollars to the other company. So it's very complicated. And remember they had this thing, and I have no idea where the status is now. I went down to IBM. It was in IBM Almaden where they were doing this.
Yeah. Right. It's really hard to think of something really new and innovative and something that no one has thought of before. And that process is really difficult, right? Like there's not many of us who can really have the ability to do something like this. And then you're asking them to have the financial wherewithal to support this process, and then the legal understanding to go through this. That's a really tough mountain to climb for a lot of people. And so this is, I actually quite enjoy helping people with the patent process because it's such a, it's so complicated. My advice kind of helps, stabilize people's like distraught over the situation sometimes. And sometimes it's devastating. They didn't realize how much they had to kind of go through. So that's the good and bad about this. Just as a heads up, I am now blowing past 2 meetings. Okay, so does anybody have any other questions? It's okay if you do. I just want to make sure that I can answer everyone's question.
Nope. And Richard, thank you. This was really, really good. Thank you.
All right. You're welcome.
Thanks, Richard.
Yeah, hopefully it was
Thanks.
informative and entertaining.
Thanks, Richard.
All right.
All
Thank
right.
you everybody for attending.
Later.
All right. Bye-bye.
Bye.